this defendant, Daniel O'Brien, was looking for a way to fulfill his self-admitted sexual attraction to teenage girls. Which better teenage girls to target than the most vulnerable and desperate of them? Where better to find the most vulnerable and desperate teenage girls but on the internet? Where better on the internet to find desperate and teenage girls? 43things.com, where, as you will see, there is a plethora of reported teenage girls desperate, looking for help to run away from home. On October 23rd of 2009, this defendant responded to gmail.com's posting. You have the posting. She is desperate to get out. What better target? What better opportunity for this defendant to take advantage of? And that's exactly what he set out to do on October 23rd when he reached out to her. Ladies and gentlemen, it is the defendant's actions, his conduct, and his intentions between October 23rd and November 20th of 2009. He responded to her with the specific intent to try and meet her, with the specific intent to try and sexually assault her. And that's what he set out to do. You will have the email communications, and I caution you, to them out, there will be a lot of duplications when there are responses. All of the prior emails and responses are included, so you have the actual printouts from that day. You have the dates and times, and you have the conversations. Of course he was nice. Of course he wasn't going to indicate his specific sexual intentions in those emails. He didn't want to scare her away like the other girls were. He told Detective Pinard and Agent Coffey that he had made attempts before and communicated with girls, but they always fell through. And he didn't want to make sure that happens this time. So he played it nice. He's very nice and polite. He wants to help her. He wants to help her get out. And that's all he does. Every couple of days he checks in just to make sure she's still on board. How you doing? Making small talk. Talking about bringing your birth certificate and your passport because I'm going to move to Canada. This is what he's communicating with her. And she bites. Here's this reportedly nice guy trying to help her out. What 32-year-old adult male is going to try and help an unknown 12-year-old girl run away? The very actions of communicating with her, by giving her hope in those email communications, he is acting with a complete reckless disregard for the well-being of a desperate and vulnerable 12-year-old child. He is giving her hope that she will be able to get out of her house and she will be okay. What reasonable person would do that? He doesn't know her. He doesn't know her parents, what their intentions are. He doesn't even know what's really going on. He was reckless in his email communications, encouraging her to run away from home. That, in and of itself, is reckless endangerment of a child. That conduct, that communication, and the intentions behind it. A 12-year-old child is not able to take care of himself out in the world having run away. She would have been at risk if she ran away from home with no one knowing where she was. She would have been at risk for sexual abuse, certainly by the likes of him, or potentially serious physical abuse. We know that his intentions were sexual in nature. So by him even encouraging her to go with him, she was at risk for sexual abuse. It does not matter what didn't happen in this case. A lot of questions were asked on cross-examination. A lot was made in argument about we don't know what would have happened. It doesn't matter. We will have the instructions. It is the defendant's conduct, his actions, and his intentions that are at issue here. It doesn't matter why 12-year-old wanted to run away from home. It doesn't matter what the circumstances were within her home. It doesn't matter if her desire was rational, irrational, justified, unjustified, right or wrong. That is completely irrelevant. She wanted out, and she wanted help. He was more than willing to offer that help. The defendant took a series of steps in furtherance of the agreement between the two of them. Let's make it clear, he is not charged with the actual kidnapping. So it doesn't matter that she wasn't there and that he couldn't have taken her from that train platform that afternoon. But had he met her and taken her onto that commuter rail train back to North Station, that act alone, by him taking her in that commuter rail train with the purpose of taking her out of Massachusetts, would have been the kidnapping. If he had the intent, after taking her from the Littleton T station, with the intent to take her out of Massachusetts, that would have been the kidnapping. This was substantially more than just mere preparation or mere fantasy. The plans were made in those email communications. From October 23rd, they began discussing him coming up and getting her and bringing her back with him outside of Massachusetts. He says, Thursday the 19th, I'm going on vacation for a few weeks. I know it's a few weeks away, but that's the first that I'll be able to do it. He then changes it to Friday, November 20th, because that's when it's cheaper for him to have gotten the ticket. 1 week to the day that he first made contact with her on October 23rd, he purchases the tickets. That takes it from mere preparation, mere planning, to action. You will see from the internet communications, the internet searches from the defendant's computer, that on the day before, October 29th, he's searching, I'm 32 and had sex with a 12-year-old. Talking about selling runaways, getting his daughter pregnant. This is on the day before he purchases those bus tickets that set this plan in motion. Again, between October 30th and November 20th, the plan changes yet again. She wants to get away and she doesn't want anybody to know about it. So the initial plan was the Littleton Middle School. She provides a link in one of the communications so that he can get directions. She indicates it's only a couple miles, it's within walking distance of the train station. But then she figures, well, maybe we shouldn't meet at the school, and she changes the plan in the days before November 19th, their last communication, to the Littleton commuter rail station. That is the agreement. That is where they agreed to meet. And the defendant, on the night of November 19th, at 10:20 p.m., gets on a bus in Richmond, Virginia. He gets on the bus with the bus ticket to get up there and the return tickets to get back from Massachusetts. Not just one, but two. One in his name and one in the So he's now not only purchased the bus tickets, but he's gotten on the bus. Yet another act towards fulfilling this kidnapping. He gets on that bus in Richmond, Virginia, travels to Washington, D.C., transfers to another bus in Washington, D.C., takes the bus to New York, transfers to another bus in New York, and takes the bus finally to Boston. Each and every time he transfers buses is yet another step towards accomplishing this kidnapping. He gets to South Station where the Greyhound bus pulls in. As he stated, he took the red line to the orange line to get to North Station to grab the commuter rail out to Littleton. He arrives at the Greyhound station in South Station. He purchases a Charlie ticket to take the subway, yet another act towards accomplishing this kidnapping. He gets to North Station. He buys 3 commuter rail passes to get out to Littleton, 1 for himself to get out there, and 2 to return from Littleton back to North Station. Yet another act towards fulfilling this kidnapping. And he gets on that commuter rail train, and he goes out to Littleton. When that train pulls in, he and he alone steps out on his own free will to that subway platform. Exactly where it was that he planned to meet. Exactly where it was that he was going to turn around and take the 3:34 p.m. train back to North Station. Exactly where it was that he needed to be to accomplish the kidnapping. This defendant did everything he possibly could have done to accomplish this kidnapping. She didn't show up. That's the only thing that stopped it. And that is why he is charged with the attempt and not the actual kidnapping. This was not mere preparation and planning. This was virtually full execution. What were his intentions? Ladies and gentlemen, what 30 or 32-year-old adult male, out of the goodness of his heart, wants to help an unknown 12-year-old girl run away when he lives in Virginia and she lives in Massachusetts? He wasn't just going to help her out of the goodness of his heart. He was going to get something else in return. And this girl was so desperate and so vulnerable that she was the perfect target for him to be able to exercise power, influence, and control to get from her what it is that he wanted. It doesn't matter what he could or could not have done once he got her back to Virginia. It doesn't matter the fact that she didn't show up. It is his conduct, his actions, and his intentions. Email communications included one fact that will help you decide what his true intentions were. Yes, he wanted to take her out of Massachusetts. That's entirely clear. He certainly had an intent to kidnap her by way of what the law states for 12-year-old children. He told her that he was only 25. Why did she care if he was 25 or 32 if all he was going to do was help her run away and bring her out of Massachusetts? He stated he was 25 rather than 32 because he ultimately wanted her to willingly engage in sexual conduct with him at some point. He wanted to make himself sound younger so that maybe this 12-year-old girl would voluntarily engage in this conduct. We have, ladies and gentlemen, his admissions, his statements to the detective and the agent about what his intentions were. When asked, what was your plan? Without prompting, without leading, without suggestion from Detective Bernard or Agent Coffey, he said he wanted to do sexual stuff, touch her and suck on her body. He admitted he wanted to take her back, make her his girlfriend, marry her, and have children with her. He admitted he wanted to have sexual intercourse with her. You have the internet searches to also find evidence of what this defendant's state of mind was, what his intentions were. Before he even purchased those bus tickets, he was looking up him being 32 and having sex with a 12-year-old. He wasn't going to wait until she became legal. He had intentions to do what he could with her as soon as he got her within his power, influence, and control. The fact that it may not have happened or that it could not have happened, that is not for you to consider. It's what his intentions were on that day. In addition to his statements to the detective and the agent, you have, again, the internet searches that you'll have before you that show you what his state of mind was in the days and weeks before he traveled to Massachusetts for purposes of kidnapping this 12-year-old child. Ladies and gentlemen, this defendant took advantage of an opportunity. He took advantage of this defendant took advantage of the trust that all parents give their teenage children in allowing them to use the internet. Most importantly, he took advantage of a 12-year-old child who was vulnerable and desperate. The Commonwealth has now had the opportunity to present all of the evidence to you. The Commonwealth has had the opportunity to summarize the evidence with you at this time. It is now time for you to take advantage of the opportunity that you have to review the evidence, review the witness statements that you've heard in testimony, review the documents and the defendant's statement. Take this opportunity to let this defendant know that what he did that day, the days and weeks before, was in fact a crime. Let him know that he is guilty. Thank you.
That the Commonwealth has proven beyond a reasonable doubt each and every element of the offense is charged. When the judge has prepared the jury instructions, you'll hear him read them to you. And each one of you, I understand, will bring in a copy to take with you back to the jury. It is Mr. O'Brien's position that the Commonwealth has failed to meet its burden on some of the elements of each one of the indictments. And if you feel that they have not met that burden beyond a reasonable doubt, then it is your duty as jurors to find him not guilty. Does not mean you're going to find him innocent. Now, with respect to the attempted kidnapping, you will hear that in Massachusetts, someone under the age of 14 cannot consent to leave the Commonwealth against the will of their parent or legal guardian. That's the law. So even if somebody says, oh yeah, take me, I'm willing to go, if they are under the age of 14, that is not acceptable. And you heard from the complaining witness's mother that the child in this case is under the age of 14. So you'll be able to find that that element is present. Now, when the mother was on the stand, the Commonwealth did not ask her, well, did you object to her leaving? She never said that. The Commonwealth didn't ask it, she didn't answer it, she didn't volunteer it. So, was it against her will? You could probably speculate and say the fact that the hue and cry was raised at the police department, well, yeah, I guess it was against her will. But who raised the hue and cry? The boyfriend. He's the one who raised the hue and cry, and he told you he wasn't the parent, he wasn't the legal guardian. What has happened to this child today? They don't have legal custody. The child's awarded to juvenile court and has not been visited since the child landed in Arlington. You can speculate whether it was against her will, but you didn't have any direct evidence that it was against her will. Now, on the attempt, you'll be told that there had to be an overt act relative to the attempt. In the indictment, the Commonwealth alleges that the overt act is traveling from Richmond up to Littleton. Now, you're also, you've seen maps and tickets that you can bring back with you. Bus tickets and timetables. Judge will tell you, mere preparation, no matter how careful and how detailed, mere preparation is not enough to sustain a conviction on an attempt. So, was this planned? Was it detailed? Was it careful? Who's to say? Regardless of whether it was careful or not, that's not enough to show an attempt. You'll be able to read that in the jury instruction. You'll be able to hear His Honor tell you that. Now, who is Mr. O'Brien? This is Mr. O'Brien's resume. And you heard Detective Bernard go over it with you. You'll be able to look at it in the jury room. It's obviously out of a template. There are misspelled words. He's a shoe specialist at Target. He's a cart attendant at Walmart. And he was a courtesy clerk at a U-Cross, which is somewhat like a 7-Eleven or something. There are things that should have been deleted. All the classics that you look for in a resume do not be there or present here. Like I told you in the opening, this is more sad than salacious. You hear attempted kidnapping, enticing a child, leaving a child, and certain thoughts come to mind. After you've heard all the evidence, this is more sad than salacious. Now, what happens in this plan? You have the emails going back and forth between them. Couldn't get anywhere. I can't get anywhere to meet you unless it's a few miles. I can't get anywhere to meet you. I'll probably go sooner rather than later. It's pretty tough around here. My stitch is pretty tough at home. She's the one who sends the email changing the location from the school to the train station. She puts that notice out on that 43 something. You'll be able to see that, where it's very sad. She says, I don't care if you're, I don't care, it's got to be better than what I've got going on here. You heard her mother and the living boyfriend tell you, yeah, she seemed to be happy at home. Happy at home? What kind of child who's happy at home puts out this information on the web and sends these kinds of emails? Did this person need to be enticed? The judge will tell you what enticed means. The legislature has taken the time to define enticed. There's a laundry list of words there. This child was not enticed. This child was an active participant in this plan. So with respect to the enticed part of the indictment, I would suggest to you she did not need to be enticed, as that word is defined in the statute. You will see on the 11th November, where she tells Mr. O'Brien in an email, well, if you want my birth certificate, we may travel to Canada. Is my name going to be on some kind of watch list or some kind of missing child list? Then look at exhibit 11, I'm sorry. On the 11th of November, that's when the visit occurs to the websites. Missing children, requirement to travel overseas. Any thought of it. She's the one who raises the issue. After her email goes out is when those websites are visited. The judge will tell you you are allowed to use your common sense, your everyday experience, your collective common sense, your collective everyday experience to arrive at a verdict here. I would suggest to you that today, to think that you are going to get on an interstate carrier, even a Greyhound bus, and not have some form of identification is ludicrous. More ludicrous than lurid. How are you going to get on the Greyhound bus with this child who, under the age of 16, so she doesn't have a driver's license, probably doesn't have a license from the registry or some kind of identification from the registry of motor vehicles. You have no evidence in front of you that she had any form of identification. How is she going to get on that bus? Whatever she would have had with her certainly didn't have O'Brien on it. It had. How is she going to get on that bus? Anyone stop to think of that? Apparently not. No birth certificate, no social security number. Let's talk about. He lives in an apartment complex with his mother and his brother. What's going to happen? Well, that makes something up. I hope it's good. How are you going to explain to Mom that there's this 12-year-old girl here? What's Mom going to do? Well, I don't know. You going to take pictures of her? Yeah. How? Yeah, I got a rinky-dink camera. I don't know how I'm going to take pictures of her. He doesn't have a plan. It doesn't come together. He's making it up as he goes along. It's fantasy. And you heard from Detective Kennard frequently while he was being interviewed, he used the term a fantasy. It wasn't real. Well thought out, careful plan. He's serious about doing this. He's got $8.30 on him. 2 Dunkin' Donuts at the train station waiting for the train to come. That's gone. And she has $50 on her. A lot of money for a 12-year-old. In the real world, how far is $50 taking you? This plan was ludicrous from the get-go. It was not happening. He gets off the train. I would suggest to you that Mr. Kennard and the other police officers and FBI agents jump the gun. Because when she's not there, how do we know he wasn't going to sit down there passively and word Detective Kennard used to characterize the person. And say, no, she's not here. I'll wait for the next train. How do we know he didn't take out a map and say, oh, school's this way, I'll start walking to school? We don't. Why don't we? Because they tackled him. He could have changed his mind. He could have backed out, especially when she wasn't there. But we don't know, do we? And we don't know because even though there's 3 Littleton police officers, 1 the number 2 guy in the chain of command, and 2 FBI agents, so they control the scene. They know what's going on. They know the child is safe. They don't wait to see what happens. He gets off the train, they call his name, he turns around, and you heard the evidence. They tackled him. So, do we know what he would have done when she wasn't there? No, we don't. We have to speculate. So if you're in that room and you're saying, what if he decided to sit down and wait for the train without her? That's reasonable doubt. Is that all the reasonable doubt? Oh no, there's plenty more. Apparently, she never went to the Facebook. When she saw her would-be knight in shining armor, do we know she wouldn't have said, look, what have I got myself into? I don't want to go. Do we know? No, we don't. We don't know what would happen when she finally saw him. And you'll be able to take this back in there and take a good look at it. What if she turned around and said, no? You don't have to speculate about that. He told you that. I'd let her go. What if she got on the train from Littleton to North Station? And on the way, she's talking to him. And she says, I'm not getting more pills in feeling. At North Station, she says, I'd like to go back to Littleton. I'd let her go. Do we know that happened? No. Why? Because they jumped the gun. We don't know. You've got to speculate as to how this would have happened. They are missing an essential element of their offense. And you can't fill that in. It has to be beyond a reasonable doubt. And that's why I told you in the opening, as hard as it may seem, you're going to hear some very bad things. But when you think about it, and you think about the law, no crime here. With respect to endangering a child, you heard testimony from him. What are you going to do? Well, I'll take pictures of her. Okay, what kind of pictures? Well, she's going to wear a short skirt, low-cut blouse. So what? There's nothing wrong with those kind of pictures. What are you going to do with them? You're going to put them on the internet. Yeah, well, she's under 16. I'll blur out her eyes and her face. You know how to do that? No. Have the equipment to do it? No. It's part and parcel of this whole thing. We get the knee-jerk reaction, but when you start thinking about it, we don't know how we're going to do it. What are you going to do when you get her down there? Oh, later my girlfriend, eventually my wife. Oh, suck on her body, I guess. And what's the next thing he says after I guess? I really don't know. Once again, the Commonwealth is asking you to draw an inference. They're asking you to say, well, this is going to happen within minutes of rolling into Virginia. Someone who's 12 years old and can't get married in Virginia. Even with parental permission. So there's got to be a time frame going on here. Were they going to lie about her age? I don't know. Again, we're speculating. Were these activities going to happen as soon as they get to Virginia? I don't know. Where were they going to happen? Assuming they hadn't spent a cent, between the two of them, they get $58.30 when they're in Virginia, provided the mother says, hey, out of here, this isn't happening. On the other hand, if the mother says, what? Picks up the phone and calls the police, then nothing's happening there. But we don't know. You have to speculate. You have to speculate. He's entitled to the benefit of the doubt. You've often probably said that in your lives. Now you're in a position where it actually means something. I gave him the benefit of the doubt. Before, you probably just shrugged that off or just routine saying. Not a routine saying today. Not a routine saying for him. If you have a doubt, and that doubt is reasonable, keep in mind, ladies and gentlemen, the doubt has to be reasonable. If it's a reasonable doubt, he gets the benefit. You have to go not guilty. On the attempt, obviously the third one, the defendant's act did not result in a completed crime. They can probably show that. The kidnapping, such as they charged it, didn't happen. What else do they have to prove? That he had a specific intent to commit the crime, and that he took an overt act towards committing the crime, which was part of carrying out the crime, and came reasonably close to actually carrying it out. I would suggest to you that getting off the train in Littleton and nothing else, where the intended victim is not even at the train station, you need to do a little bit more. You need to at least start traveling to the school where you think the victim is. You need to travel to the house where you think the victim is. But simply getting off the train station and nothing more, is that enough of an overt act for an attempted kidnapping? Keep in mind, these two have never seen each other. They have never laid eyes on each other. She never even looked at this Facebook picture. You're supposed to be wearing a black baseball hat. Your Detective Bernard said he wasn't wearing a hat. So, how was she going to recognize me? He didn't even have on everything he told her he'd be wearing. Now, you heard Lieutenant King say, well, he was kind of staring along. Then he got more animated when he came to the train station. Who doesn't? We're on a train. There's nothing to look at. One tree looks like another tree. Now you have to get off. You're looking for where the door to the thing is. We have to exit the train. Who knows? Everybody else there obviously became animated when they pulled into the station as well. What did Lieutenant King bring to the party? Not too much, other than he participated in the arrest. For the enticement, they have to show three things. I would suggest to you they can show the second, that she's under the age of 16. I would suggest to you they cannot show the first and third, which is that she was enticed, and that she was enticed to enter, exit, or remain within a vehicle, dwelling, building, or other outdoor space. First of all, you're going to see the emails. You can read them for yourselves. I don't need to read them to you. Secondly, how can she be enticed to enter a vehicle or not? She's not there. He's never seen her. She isn't gone to the train station. He's not charged with attempting to entice her. He's charged with the enticement. She's not there. How can this happen? The third element is that he did this with the intent to commit the crime of rape. Again, they're asking you to infer there's going to be some sort of sexual contact here. You heard the tape. You heard the DVD. When was that going to happen? And he said if she said no, she said she wanted to go home, he'd release her. So why should we believe the bad things and not believe the good things? On the reckless endangerment, they have to show three things. I think they'll be able to show the third. The person placed at risk was a child under the age of 18. The first one, he engaged in conduct that created a substantial risk of serious bodily injury or sexual abuse, or failed to take reasonable steps to alleviate such a risk. Again, they're asking you to infer. Now, you're going to hear that you're allowed to make inferences. The inferences have to be reasonable. And so, would you be able to infer from the tape, from the websites, would you be able to infer that some sort of an assault was planned? Maybe. But would you also be able to infer that this is something that's going to happen down the road? That's also a reasonable inference of crime. And if there are two of them, and they're reasonable, he gets the benefit of the doubt. So I would suggest to you that, as I indicated to you when I first had the opportunity to speak to you, no crime here. Yeah, it looks bad. Yeah, you hear the indictment. What do you mean there's no crime here? We're in Superior Court. I'm here. My schedule has been disrupted. The jury service. What do you mean there's no crime here? Now you understand what I meant when I told you. There is more than enough room here, ladies and gentlemen, for reasonable doubt. More than enough room. And I would suggest to you that the Commonwealth has failed to prove one, in some cases, two elements on each of the indictments, without the ability to prove beyond a reasonable doubt each and every element of each and every indictment. He gets the acquittal. You're not finding him innocent. You're finding him not guilty.